as I see it, as y'all have explained it, there are two options for what I can give you. Either Miss McMillan is a tenant who's not paid her rent and she's evicted today for non-payment, or Mr. Patel doesn't have a tenant because she hasn't resided there in well over a month, and as a result, case is dismissed. Mr. Patel, Miss McMillan, I recognize that we've seen each other before.
Yes, ma'am.
Okay, so let me ask a few questions, because my hope is that I can, remember the court is an impartial third party, but my hope is that by having you both today and asking you some questions, maybe you both can get where you're aiming to go. Because I know that you both want something. It's a matter of, let's see if we can all get there, okay? So, Mr. Patel, let me ask you a question. Is Miss McMillan physically, I understand she has items, but is she personally, as a human being, is she currently residing in, was it number 105?
Yes.
Is she currently using number 105 for more than just her items?
Yes.
When is the last time, to your knowledge, that Miss McMillan came and used the room?
Well, I have no idea, ma'am. I'm working 24 hours. I got to do what I was doing here at the front desk. She's come and gone.
Okay, all right. So you don't have personal knowledge. Mr. Patel, here's my other question. When's the last time Miss McMillan gave you any money?
The last time she gave me money was on sometimes in September 2025.
Okay. And Mr. Patel, you are a hotel operator.
Yes.
All right. And in September, what room was Miss McMillan paying for?
105, room number 105.
What kind of key is that?
It's a key, electronics key card key.
And per your terms and conditions, have you changed the key card on her?
No.
Why not?
I mean, I'm sorry, what you said, the key card holder?
Yeah, like, is it like you have an electronic key and you charge it to that room, or is it a physical key that is keyed to a deadbolt?
No, it's not a physical key, no. It's just a key, electronic key card where you touch by the lock and it gets open.
Miss McMillan, are you still living in Unit 105?
No, ma'am.
Where do you live?
I live in a temporary place right now.
But you don't live in Mr. Patel's hotel anymore?
I have not been there since October of 2025.
As I assumed, because I've heard this testimony from both of y'all before. Okay, so not a tenant. Miss McMillan, do you still have items at the hotel?
Yes,
Are you
Your
wanting
Honor.
to get those items?
Yes, Your Honor.
Okay, Mr. Patel, are you interested in Miss McMillan coming and getting her stuff?
Yes.
I'm going to give y'all court's information, okay? Because I would love to get you where you want to go, but the way you're both pursuing it is not going to get either of you what you want, okay? So, Miss McMillan is not a tenant. She has not been a tenant in ordinary course as a tenant under the law since at least September, October, November. You are a lodger, Mr. Patel. As a hotel operator, your own receipts tell me that it is a lodging situation. She was paying to be a lodger for 30 days in advance, and then she stopped paying, at which case she's no longer a lodger. You're a hotel operator. She's not a tenant. That's why when you previously tried to evict her, I said you can't because she's not a tenant, right? If what you're trying to do is recover money or get rid of her stuff, there is a different mechanism for that. It's a different kind of civil suit. But an eviction will not get you where you want to go because she's not a tenant. In the same vein, Ms. McMillan, if you want to recover your items, a writ of reentry will not do it for you because you're not a tenant. If you are interested in filing a writ of retrieval, you might be eligible for that. And that is the document that you might want to encourage or look at or talk to legal aid about. Is this something for me, right? Now, that's just legal mechanisms. Mr. Patel, as a hoteler, you have rights and responsibilities for items that are left in the unit once someone leaves the hotel. You can contact any legal attorney you want about what to do with those items. Having said that, there's nothing whatsoever that prevents the two of you from agreeing to have a time where you come together. Ms. McMillan gets her stuff, and then Ms. Patel, you get your room back. But she's not a tenant sufficient for an eviction. And Ms. McMillan, likewise, I cannot give you a reentry because you don't have the right to be there. You both may have some other things you can do about the property that remains, if indeed you want to go and get it.
Excuse me, Judge. I already had a writ of reentry
I know.
in this case, and I already won an eviction. I prevailed in the last one.
Ms. McMillan, I agree. He can't evict you because you're not a tenant. And I gave you a writ of reentry, but once we tried to serve it, we found out it didn't really qualify anymore. And so at this stage, if you filed for a new writ of reentry, I would deny it for the very testimony you just told me. You're not a tenant. A writ of retrieval, writ of retrieval may very well get you back the same things you want.
We have an oral lease, just like with the Acostas that had an oral lease. I've been paying for over a year and a half, month to month, oral lease. And
Ms. McMillan.
And I had you heard the video of him saying I'm a tenant. It was a tenant. And there's other people that are tenants there in cottages there.
Ms. McMillan, Mr. Patel, the court has exhausted its information that it provides you. And I will say it again. I don't find any of your testimony to establish for me a lease here. Not anymore. You may have once been a tenant, but you're not. If you're trying to get back your property, there is another method for that. And Mr. Patel, if you're trying to remove her property, please seek legal advice as to how to do that. There is not right now a sufficient landlord-tenant relationship between the two parties. So an eviction is going to fail.
How could I have won an eviction and then been locked out and I prevailed in it, and then now all of a sudden I can't win another eviction? How is that even possible?
You're winning the eviction because you're not a tenant, Ms. McMillan. That's what I'm saying. You keep saying you won the eviction. You were sued to be evicted, and you won because you weren't evicted, and you can't be evicted if you're not a tenant. It's like saying I can't get you divorced if you've never been married. Y'all are not married anymore.
It was because he didn't give a proper notice to vacate. That's the reason why.
That was then. Today, though, right now, Mr. Patel
It's the same situation.
Ms. McMillan,
he refiled and he refiled and he refiled.
Do you want to be evicted or do you want to win again?
I just want my stuff, but I have more rights.
Ms. McMillan, I've even called legal aid on your behalf. Look at, I'm going to say this, writ of reentry will fail because you are not a tenant, as you just testified. There's other versions out there.
That's not what I testified to. I testified that I have not been able to stay there, as is my legal right, since October of 2025 because of his violence. I would have stayed there if the owner would have been served, the true owner. I had every right to be there. I prevailed in the eviction. I haven't been able to stay there because I'm afraid of this guy because of his violent behavior.
Ms. McMillan, have you paid rent for January or December?
Buckle up, guys. Today we are stepping into a courtroom where the tension is already thick before the first real question lands. The judge immediately signals this is not their first encounter, which tells us history is driving this conflict. There's familiarity, but not comfort. You can sense unfinished business hanging in the air. The judge positions herself as neutral, yet clearly hopes to push them toward resolution. Both parties want something, but neither seems aligned on what that actually means. This short opening plants the seed of dispute. It hints at legal confusion. It sets expectation for confrontation. And it quietly promises that clarity is about to collide with emotion.
No. Then he owes me money.
Ms. McMillan, then you would be evicted today for non-payment. You see? Either you're evicted.
But he didn't even file the proper notice to vacate.
I actually don't see that. It looks like his notice to vacate was fine. I just said it's failed.
Can you file a notice, which I haven't even been served, so I haven't even seen it. He doesn't ever serve any of the documents that he gives to you all. And then can he file a notice to vacate when the appeal window is still in the appeal for the last eviction?
Yes.
Yes.
Really?
Yes.
Okay.
The landlord can exercise all of their rights. He can appeal and give you notice to vacate all in the same day.
And then he can reuse the same notice to vacate because he dismissed that eviction and he refiled the same day and did not give me another notice to vacate.
He can try, but I've just
No,
found
no.
against him.
Ma'am, I did. She came on December 5th. I did, like the way, in an envelope, set it up outside and inside the room. She came and picked it up.
As I see it, as y'all have explained it, there are two options for what I can give you. Either Miss McMillan is a tenant who's not paid her rent and she's evicted today for non-payment, or Mr. Patel doesn't have a tenant because she hasn't resided there in well over a month, and as a result, case is dismissed. Neither of you are happy with that outcome, but that's what I'm left with, and that's the ruling. Court says plaintiff take nothing. I don't find that Miss McMillan's a tenant, and Miss McMillan, no other conversation. Please contact legal aid about how to recover your property when you are not a tenant. There is a method for that. There's a form for it, and I am happy to sign it, and you can go and get your stuff from Mr. Patel, who wants you to get your stuff and leave.
Okay.
All parties are excused.
Is it like a
Ms. McMillan, what's that?
Alright, guys, this is where the legal unraveling begins. The judge methodically dismantles the central claim by focusing on one decisive issue, tenancy. Payments stopped in September. Residence stopped in October. That changes everything. What feels like eviction drama is actually a classification problem under property law. The court draws a sharp line between tenant and lodger, and that distinction collapses the entire eviction strategy. The defendant insists on an oral lease, but the judge rejects it as legally insufficient. Every attempt to revive the tenant argument meets procedural reality. This is escalation through logic. It's not loud, but it's devastating. By the end, both sides realize the case they thought they had is slipping away.
how long do I have to get it? Did you see like the U-Haul reservation that I had already like planned before he locked me out? I still don't have a key. I'm afraid of this guy. I've asked for protection from this man since I filed the original writ of reentry. Like, you guys aren't protecting me at all. I would have gotten my stuff out. I don't want to have my stuff over the holidays. Ms.
McMillan, please contact legal aid again. Please. Okay, and Mr. Patel, please contact a lawyer, right?
Yes, ma'am. Uh-huh.
It strikes me again and again, you're both just this side of where you need to be, especially when you both seem to be wanting the same thing, which is Ms. McMillan to get her stuff back. All right.
Is he going to let me get my stuff back safely?
Yes.
Parties can absolutely arrange that on their own, right? I
have a lot of filings that I've asked to be filed, that I've asked to have the court look at, and
Ms. McMillan,
one of them is...
I have reviewed them, and I have been as clear as I possibly can with you.
Okay, so you're not going to file to protect me. So you're not going to file to make sure that I'm protected.
I will never file on your behalf, Ms. McMillan. I'm the judge.
No, I mean find for me to be protected. And how do I get a key? And he's told me that I cannot contact him to obstruct. So okay. How do I do all that? All
parties are excused. I don't think we're being very constructive. Please contact either Texas Rio Grande Legal Aid or any legal aid services about recovering items when you are no longer a tenant. Because you're not a tenant. That's why you're not evicted. And Mr. Patel, parties can, everyone seems to want the same thing. I want y'all to have the same thing. But legally, it's not an eviction, and therefore it wouldn't be a writ of reentry. Y'all are past that stage.
Now we enter the fallout, and this is where emotion overtakes structure. The judge delivers a ruling that technically favors the defendant, yet satisfies no one. She's not a tenant, so eviction fails, but that victory feels hollow. Fear replaces argument. The focus shifts from legal labels to personal safety and property retrieval. The defendant wants protection, a key, certainty. The judge insists the law has limits and directs her elsewhere. What unfolds is frustration meeting jurisdictional boundaries. The courtroom becomes a place of procedural closure, not emotional resolution. Appeals are mentioned, confusion deepens, and authority draws a firm line. The case ends not with clarity, but with unresolved tension hanging in the silence.
I don't understand how that could even be, but how do I even go about to get a key and get my things?
Ms. McNilan, that's legal advice. And per what I'm saying is you don't have the right to have a key because you're not a tenant.
But I was a tenant, but now I'm not a tenant, even though everything is the same.
Yes.
Like I had a
Ms.
key.
McNilan, here's why. Because you don't have a lease. You were staying in a hotel and your time for the hotel came to an end and you didn't pay.
I have an oral lease. I have an
don't.
oral lease longer than the Acostas that you just said had an oral lease for a bunch of guys that might have been squatters.
Ms.
And
McNilan,
and you said that
Court
it's
is
an oral
over.
lease, and you know, like, but I don't have a lease.
You don't.
Like,
All parties are excused. Thank you very much.
how do I appeal? Do I have the 5 days to appeal?
You've won, Ms. McNilan. What are you appealing?
I'm appealing because he's going to do something to my stuff, and I don't know how to get a key to get my stuff, and you're not keeping me protected.
Ms. McNilan, we're done. Court is over. Please contact Texas Rio Grande Legal Aid about a writ of retrieval.
You're the one who said Texas Rio Grande Legal Aid is not good, and you're right.
No, they're
and I
great.
tried to find. You're the one who.
It's outstanding. I know they're very
Okay.
busy.
No, you told me that they were, when we had issues on this before during the writ of reentry, you said there was a problem with them, and there is. And anyway, that's I mean, I've got to get this stuff on the record.
We're not a court of record, Ms. McMillan. That's why you can appeal de novo. All right. All parties are excused.